So welcome everybody to concurrent session A1. The title of the session is Catch-22 Conditions of Community Supervision for People with Brain Injury. My name is Connie Coburn, and I'm joined by Jennifer Dalmeda, and we'll be your facilitators for the session. Before we get started, I'll review some quick housekeeping notes, and then I'll introduce our speakers and begin the session. I'd like to draw your attention to the bottom of the screen where you'll find the Zoom toolbar. You can use the Q&A feature to submit questions throughout the presentation, and then we'll respond to them at the end. Please ensure your microphone is on mute until the Q&A session of this session, please. And during the session, there will be interactive questions, part of the session. Please put your answers in the chat box. Please note that we will be recording this session to upload to the conference website for future viewing for anyone who's registered for the conference, and you'll be able to access the platform for 90 days following the conference. I'd like to remind everyone that we have closed captioning for all of the sessions today, so please click on the CC icon below the video window on your screen to access this function. We kindly ask that you complete the evaluation for this session by clicking on the session in the agenda on the virtual platform. There will be a survey button at the bottom of the session next to the join button. Your feedback's really appreciated and will be used to inform future events such as this conference. We would like to respectfully ask all of those attending today's session to engage with each other thoughtfully and always consider the impacts of your words and interactions on others. As facilitators, we will not tolerate any abusive or inappropriate behavior or hate speech, and will ensure that anyone who engages in such behavior is removed from the session. If you've been disturbed or affected by such an event, please do what you need to do. Take a break, step outside, practice deep breathing, and/or reach out to someone you trust. If you're in crisis and require immediate support, please click on the FAQ icon on the conference homepage to access contact information for Connects Ontario. If you'd like to report an incident, contact the event manager, Sherry Sim, by either clicking on Assistance button on the top right menu bar on your screen to send an email, or you can text Sherry at 416-605-5975. Now on to the session. It's my privilege to introduce our presenters for this session. So we are joined by Arthur McLuhan, who is the Senior Research Associate at MAP Centre for Urban Health Solutions, St. Michael's Hospital, Unity Health Toronto. Madison Ford is the Research Coordinator with MAP Centre for Urban Health Solutions, St. Michael's Hospital, Unity Health Toronto. And Dr. Flora Matheson is a research scientist at Unity Health Toronto, Chair in Homelessness, Housing and Health at MAP Centre for Urban Health Solutions, St. Michael's Hospital, Unity Health Toronto. So welcome the speakers, and we look forward to your information.
Thank you, Connie. Just give a minute for these slides to load up. Well, thank you, everyone, and thank you to the HSJCC for organizing this wonderful conference and giving us an opportunity to share some of our work. Today, I'm going to share some of the preliminary findings of the Catch-22 study, which is a qualitative study that seeks to better understand the experiences and challenges of conditions of supervision and release for individuals with a history of brain injury, as well as the way criminal legal and professionals set, monitor, and enforce conditions in practice. And thank you for introducing me, Connie, Senior Research Associate at MAP in the Justice and Equity Lab, led by Dr. Flora Matheson, and where I work with Madison Ford as well, my co-authors on this piece. I'm a qualitative sociologist. Broadly, my research focuses on the patterns of interaction that shape involvements, identities, and inequities. I examine these themes across a variety of situations, settings, and social worlds. We work with a wonderful group of community partners, and including this project. We worked with the Breaking the Cycle Network, and without whom this work would not be possible. The Breaking the Cycle Network is a group of community and government partners who are committed to developing solutions that reduce criminal legal involvement and seek to break the cycle of incarceration and reincarceration for individuals with brain injury. In addition to our research lab, the Breaking the Cycle Network includes community support groups, people with lived expertise, justice system partners, community justice and reentry agencies, and brain injury support organizations. And now a little background to the study. You may or may not know that in Canada, like other jurisdictions across the world, the number of people under community supervision is much higher than the number of people in custody. In Canada, on any given day, there are 2.5 times the number of people under community supervision than in custody and correctional facilities. This includes pretrial supervision, probation, and parole, as well as some other forms. Being under community supervision places one under a restrictive set of conditions, a set of prescriptions and proscriptions, do's and do nots with which people must abide in the community. Violations of these conditions can result in further criminal legal consequences, in turn, including new charges and return to custody. At this point, I'm going to engage the audience right out of the gate. And so I turn it over to Madison Ford, who I believe will ask a question in the chat. And I'll just give you a minute or so to get back to us.
Thank you, Arthur. I'm gonna put this question in the chat so that everyone can see it. And feel free to add your responses in the chat as well. I'll read them out from there. So the question is, what are some of the brain injury related challenges in cognition, communication, behavior, and emotion that may make compliance with conditions of release and supervision difficult? So feel free to put some answers in there and I'll see what we have coming in. So we have initiation and motivation, seeing a lot of things about memory, so remembering appointments, understanding cause and effect, lots of memory issues for sure, routines, impulse control, that's in there a few times, attention processing, challenges relating to emotions and being appropriate with the services that they're mandated to engage in, being labeled as aggressive, so having a bad attitude, prescription meds, the side effects of meds not being recognized, a brittleness of thoughts, very concrete and hard to penetrate that thinking. Some stereotypes, difficulties securing employment, agitation, time management skills, problem-solving skills. Yeah, all of these are great answers, definitely very relevant. Again, memory and organization of thoughts and skills, impulse control, yep. Understanding, not organized to follow through effectively. Logistical issues, definitely that as well.
Patience, yes. I mean, you're anticipating like a number of the illustrations that are coming up. We could probably just end the presentation here on the first question. We have a room of experts, which is always nice. And will make my job much easier. Okay.
Awesome.
So let's
Thanks
move
everyone
on.
for your answers.
Yeah, the first poll question. Thank you, Madison.
Yeah, for sure.
So yes, brain injury, most research on brain injury and criminal legal involvement it's not a huge area. Okay, it's tended to focus on the relationship between brain injury and incarceration. And so just some quick stats for you here. Individuals with brain injury are about 2.5 times more likely to become incarcerated. Once incarcerated, they're about 14, 15 times more likely to rack up serious disciplinary charges while inside. Upon release, they're about 2 times more likely to be reincarcerated. So what is going on here? Well, one of the mechanisms of that re-involvement and cycle of incarceration may be through violations of community supervision orders, which most people are under upon release. There is a small but growing set of studies at the intersection of brain injury and community supervision, uh, and yes, research suggests and posits that the challenges in these four key domains around cognition, communication, behavioral and emotional control all may have an effect in the poor outcomes, poor supervision outcomes in the community. And so we see higher rates of behavioral infractions, treatment non-adherence, failing to appear for mandatory appointments, and probation and parole violations and revocations. There is also some research that suggests limited awareness and common misconceptions about brain injury among supervision officers. And so some of those challenges associated with brain injury may be misinterpreted as intentional noncompliance, defiance, disengagement, for example, and all of these may contribute to poor supervision outcomes as well in that essential supervisor-supervisee relationship and dynamic. And so there is a small but growing set of studies at the intersection
Yes, I have.
Of brain injury and community supervision. But to our knowledge, there has been no qualitative work in this area. And so enter this study and the rationale for this study, which has three primary objectives: to examine how individuals with a history of brain injury experience and manage conditions of release in the community, how criminal legal professionals set and enforce these conditions, and to examine how interactions between criminal legal professionals and persons under conditions shape compliance and violation trajectories in distinct ways. Little on the methods, as I know this is a qualitative study, and we're trying to unpack and interview and get a sense of the experiences and strategies of all of the key players in the community supervision process. Of course, people under supervision, friends and families who support people under supervision, including as sureties, service providers, both criminal legal professionals who apply, monitor, and enforce conditions, as well as community service providers who support individuals under conditions in the community, and Indigenous elders who work with individuals under conditions. One of the key eligibility criteria for folks under, for participants under conditions was to screen positive on the HELPS brain injury screening tool. And here's a little overview of the participant characteristics thus far. We have interviewed 25 people under supervision, including 12 women and 13 men. 22 service providers, including lawyers, duty counsel, police officers, judges, community service providers, parole board members, bail supervision officers, and 4 friends and family. All right, the bread and butter, the meat and potatoes, the main dishes of this presentation are focused on 2 parts: the challenges of conditions, and later on we'll consider responsive approaches. So in walking through some of the challenges of conditions, I'm going to try to follow the process from initial first contact and criminal legal involvement to police custody, through the courts and into the community under conditions, and try to illustrate some of the perspectives and experiences, not only of people under conditions, but all these other key players in the process. But before I get to that, I wanted to, and I'm expecting, based on your first set of responses, some sharp answers here as well. I want to poll the audience yet again to get a sense of your experiences and expectations around what some of these challenges of conditions might be. Madison Ford.
Yeah, so I'm gonna pop another question in the chat and we'll just do the same thing as the first one, have everyone answer in there. So the question is, What do you expect are some of the common challenges people with brain injury experience under conditions of release and supervision? Missing appointments, definitely. Struggling to complete programming, for sure. Comprehension of conditions, definitely. Memory, again, yeah. Managing appointments, impulsivity, difficulties communicating their needs to probation and parole officers, experiencing frustration with not being able to meet appointments, reintegration into the community, lacking support, medication compliance, again, memory and communication. Communication seems to be a big theme as well. Prioritization, difficulty regulating self when engaging in regulated programming. IPV, follow through, safety, comprehension, and communication, understanding the specific next steps they need to be taking, difficulty understanding the court process, difficulty with transportation, again, understanding the conditions, navigating between service providers, seeing comprehension and self-awareness, houselessness, acting now and not caring about the future outcomes. So it's tying back to impulsivity there. Wait lists for services that would be beneficial and lacking knowledge of supervising officers to assist in accessing those supports. Financial instability, emotional regulation. Again, housing is coming up a lot as well.
Too many conditions.
Think she fucking
Yeah.
kept saying that to you?
And logistics.
All right.
Difficulty paying for
Yeah, we
services.
better put a
Yeah.
hold to this before the rest of my presentation seems inadequate.
Thank you,
This is
everyone.
wonderful. You know, based on my experience at academic conferences and, teaching at the university level, it's usually cricket. So a wonderfully engaged group. This is awesome. Okay, Madison, let's go. So I'm going to try to follow along a process here. And I thought to set the stage, we might think a little bit about first contact with the criminal legal system and how recall those domains of challenges, around cognition, communication, behavioral and emotional control. Researchers think that challenges in these areas may be what's leading people to have greater risk of conflict with the criminal legal system. And indeed, our participants provided a few examples of some challenges in these areas that might lead to that sort of conflict and initial entanglement. So for example, since my accident, I swear more, I'm angrier, a major head injury, it affects a lot of stuff, like how you act. I'd say my attitude changed and I got angrier after my injury. Another participant told us, I have an impulse problem. I don't know how to tell myself, no, I shouldn't do that. That's the head injury in itself, because you say stupid shit, you do stupid shit, you're going to get stupid shit done to you, and the system doesn't even care. They just keep putting you back through the revolving door. It's also important to note that brain injury affects all walks of life. So people are often experience brain injury in the context of other complex concerns, such as poverty, homelessness, and rough living. So there's a lot of people out there with brain injury. And if they have a temper tantrum and throw their shoe at someone, they're getting arrested for assault with a weapon. There are many people who are not necessarily well cared for by our system or slip through the cracks. We're living on the streets or in shelters, and they're having a really hard time integrating and adapting to both the rules and also the expectations. It's very hard to conform if you're not able to control your behavior. Then people think you're bad or you're a criminal or you just should be arrested. And actually, none of that is helping. Brain injury doesn't get recognized right away, and it may be identified as a mental health issue, but actually it's more complex than that. Brain injury may also affect those, of course, living more quote unquote stable lives. For example, a judge told us about 2 cases that were typical, quote unquote, of the cases of brain injury that he's presided over the years. In both of those cases, their family histories were normal. Normal family interaction, normal social interaction, normal employment history, zero involvement with the criminal justice system. And yet, In both cases, following what were profound brain traumas, their conduct rapidly became dysregulated. They were self-medicating with various controlled substances that had further knock-on effects. And both individuals had accumulated significant charges, a significant number of charges, and some of them quite serious. And so you have an increased brain injury, you have an increased risk of criminal legal contact and conflict initially. Once in police custody, how might some of the challenges associated with brain injury kind of affect your pathway through the system? Well, one of the decisions at arrest is whether to hold someone for bail or release by police, for example, under an undertaking. And the challenges associated with brain injury in those domains that we reviewed earlier, those may affect that police decision-making process. For example, a police officer told us, "How you are with uniform will dictate how my investigators are going to sit down with you. If you were compliant or not, or just like a wild man, out of control, or woman. The way you answer certain questions and the way you present would certainly be taken into account. We could release on 11.1, police released by police on undertaking. But what's going to make him or her listen to or abide by that piece of paper? If you're held by bail, often your first interaction with legal counsel is with duty counsel from the police station, and at least in the Toronto area, via an audio or video link. The connection of those links and of the quality of those connections is not always the greatest, not ideal. The booths are often in disarray, and people face other barriers to communication in that setting. And this is when you first learn about the proposed conditions, the Crown position that duty counsel will detail to clients and try to get a sense of if it's something they can work with and something that they can agree to. But often there are barriers to understanding and processing those conditions. For example, duty counsel will discuss that position with the client, see if it's feasible, see if it's reasonable, see if it's something there we can work with. Usually those positions will come with conditions that they are proposing, so we go over those conditions. A lot of the times clients have severe mental health issues or brain injury or any sort of disability that is, I think, further aggravated by them being in custody. If someone's arrested at midnight, it means that they don't get heard, until the earliest 10 a.m. the next day. So whatever condition they might have is aggravated by that in custody time and whatever happened during the incident or arrest. So those are some of the barriers to understanding conditions and barriers to communication early on in the process prior to moving through the courts. But what about in the courts? Well, most participants noted that the court process was brief, but could be difficult to follow, and that their focus was on doing and saying and agreeing to whatever they needed to get out and sort out the details later. I was happy to be signing the paper and getting out of jail. More times than not, when we're signing the papers, we're just about to be released, so our minds are more focused on seeing them later. The other piece is that conditions are often not explained in clear terms. Often people receive the court orders and then it's up to them to kind of parse this legal language. 9 times out of 10, it just looks like words. It's all written in, it looks like mumbo jumbo. You can't understand it. Another challenge through the courts, as a defense lawyer told us, is that too often the courts and the system relies on boilerplate conditions and release orders and fails to attend to the person's health and social context and the nuances thereof. This person has complex needs. They have an ABI. They have mental health issues. They have addiction issues. They're having trouble being housed because of all these things that are untreated. Let's have a more complex approach, a more nuanced approach. But instead, what you see is the judge takes out their handy-dandy laminated list of 30 conditions and just starts reading off the ones that they think would apply. It's baffling. How is that setting anyone up for success? Similarly, a justice of the peace told us, what happens is you get into the trap of the standard boilerplate. Well, this condition fits, so let's just throw that on there. The next thing you know, they're back the next morning in bail court because you put some dopey condition on there that's humanly impossible to comply with because they got a brain injury. They just don't comprehend. So those are some of the challenges prior to and through the courts. What about the challenges of conditions in the community? Well, these too are related to the self-regulation and cognitive communication limitations often. A defense lawyer told us clients with brain injuries have such mood swings. To control their behavior is much more difficult, and their ability to follow conditions is much more difficult. They don't have the capacity to what you and I would do in an executive function. They also have a harder time remembering, following the conditions. Similarly, clients with ABIs, they're not necessarily absorbing the information in the same way. Maybe there's communication issues, or they can't make it to court on time, or they can't make it to appointments on time. One of the first challenges upon leaving the courts and being released is losing or forgetting one's conditions. A bail supervision officer told us, "I cannot tell you how many people lose their bail conditions within the first 3 hours that they're released. I think in court, a lot of them just say yes, 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 just because they know they're getting out and they're not even listening or processing the terms." So that's a big issue. People losing their bail conditions, their bail papers, and not being aware of what they're actually supposed to be complying with, not even knowing their conditions. Similarly, participants told us, "I forgot my conditions sometimes, and it happened." It's easy to forget when you have a curfew, when you don't, nobody talks about it. Because sometimes the day just goes by and you don't realize what time it is. Another said, "I forget emails, I forget passwords, I forget. I have a loss of judgment. I forget where I put my wallet. I forget conversations I talk about sometimes. My wife will tell me something and I'll forget it the next second. If I read something, I can learn it that day, but then the next day I forget it." Participants also noted that some conditions could be more challenging than others, depending on their context. Place and boundary restrictions could be particularly challenging for those living their lives in the downtown core, accessing services in the downtown core, but also accumulating charges and restrictions in the downtown core. I wonder how our clients can keep up with all of these addresses, because I'm particularly terrible with addresses in the city, and I wouldn't be able to. You have to do quite elaborate navigation to avoid so many places. And that's if you're aware of where you are. And I think a lot of the times our clients, due to a variety of reasons, are maybe not aware of where they are and maybe not aware of where they're going. But sometimes it's inevitable. By far, the most commonly referenced challenging condition was just meeting and making appointments. So there are a number of different challenges around appointments. One of them was making appointments, navigating to and from appointments, especially those that were unplanned or unscheduled, but just thrust upon people by their supervision officers. For example, I have severe anxiety and stuff, and I'm in a new city, and it's huge. When they would call me in to say you have to come in now to do a P test or whatever, I don't have anything to hide, but it was stressful for me, and I would sometimes break down. They weren't adapted to be very inclusive when it comes to that kind of stuff. I manage just, but you know what I mean? It's still very, very difficult, almost impossible sometimes. Participants also had difficulty remembering all appointments, and they connected these memory challenges explicitly to their head injuries. My memory isn't that good at all. A lot of that has to do with the head injury as well, remembering appointments and stuff. I couldn't remember. A bail supervision officer told us there are added challenges with people with brain injury. I had one client very recently and he just didn't even remember. He would come to see me on a Friday and he'd come into the courthouse on Monday and be like, "Okay, I'm here to report." And I said, "I just saw you. You were in on Friday." And he had no recollection that he had reported. So if you remembered your appointment and you made it to your appointment, there could also just be challenges engaging in appointments in appropriate and expected ways. So for example, one of the challenges was going and sitting and waiting for a probation officer or something like that when I did have to go. I just didn't have patience to sit still and listen to what they told me to do. I don't have patience to sit still or go through these meetings. Mentally, I don't even know. It drove me nuts. It bothered me. It irritated me even more. I'd go nuts. I'd uproar the class. I'd start talking. I'd uproar the class just to get out of there. Participants also expressed frustration with the ability of supervisors to exercise discretion in how conditions were interpreted and applied across different supervision contexts. For example, yes, I understood the conditions, but like every parole officer, every staff member at the halfway house makes and adapts the condition to their own, whatever they make of it. Participants also described the role of the discretion on the street side of enforcing conditions. 2 police officers told us the catch-all of every single release is keep the peace and be of good behavior. And that is so up to interpretation. Like if you're keeping the peace and being of good behavior, why are you interacting with me? What have you done that I'm now having this conversation with you? Keep the peace and be of good behavior. So when you're dealing with people that have brain injuries and mental health problems, that's pretty easy to breach. Cops get called. Well, you're not keeping the peace and being of good behavior. Bingo, you're in. Let's build up the criminal record because you're going to get convicted of it. All of these challenges could leave people feeling set up to fail by the system. For example, one participant told us that special condition that they have on everything that says, do anything your parole officer says, was particularly challenging. That one really, really got to me because I'm supposed to have everything written down, a list of things that's easier for me to understand. If it's not written down, how the heck am I supposed to remember all the stuff? It just didn't make sense, especially for someone who has a disability. It feels like the world is made for people who are neurotypical, not neurodivergent. So it made me feel like sometimes things were impossible and that it was set up for failure. These health-related challenges could result in further criminal legal consequences. A defense lawyer told us a lot of my clients have problems just getting to their probation appointments and remembering them. And if you forget one and don't show up, then you get charged with breach of probation. You're back into criminal court. Unfortunately, it's a tough one for a lot of clients. So those are some of the challenges that participants shared with us of being under conditions both prior to, through the courts, in custody, and in the community. They also shared with us some strategies for supporting individuals with brain injury through the community supervision process. Before I get to some of those strategies that they shared with us and illustrations, I wanted again to turn it over to Madison Ford to poll the audience to get a sense of your expectations and experiences about what are some strategies that might support people through this community supervision process at whatever stage for better understanding conditions and complying with them in the community.
Thanks, Arthur. I already see people putting some options in here. I'm going to pop the question in there, just asking around strategies and approaches to setting, monitoring, and enforcing conditions that may help to support individuals with brain injury under conditions. So I see there phone call, text message reminders to start us off. More reminders and patience for sure. Asking support providers to attend appointments, keeping their reporting day consistent and giving written reminders when necessary. There's another good strategy here, printing out a monthly calendar and writing down reporting dates, appointments, anything like that. Not having the same expectations, providing direct support. So lots of suggestions for reminders in here. Allowing flexibility with reporting, being realistic with your expectations of these individuals, keeping support people in the loop, so keeping everyone informed that's supporting these individuals, reviewing conditions repeatedly. Consistency is also key. Text messages, meeting in a location that's easy to access. Definitely, we know that travel is an issue. and connecting with other supports who can support and manage those conditions, asking them what's best for them themselves.
Yeah.
And for those unhoused, understanding that living unhoused is a full-time job, and without stability, it's difficult to meaningfully engage with these programming and prioritizing more reminders, resources. Yeah. Arthur, should I hand it back
Awesome.
over
Yeah.
to you?
Awesome set of
Thanks so
responses.
much,
Yeah.
everyone.
Probably more comprehensive than I'll be, but I'll try to contribute to the conversation. So what did we hear? What are some of the responses anyway that we've heard from our participants? I think at a base level, given the kind of variability of brain injury awareness and knowledge in the system, it looks like we have a very knowledgeable group here, but across the system, system-wide, variable knowledge of brain injury. But there are opportunities for training and education with which criminal legal professionals should avail themselves when they can. Because it can shape and inform your practice. And so a justice of the peace told us, I think that the training is making us more aware of the acquired brain injury set of circumstances and the potential for this individual who's not a bad person to have gotten themselves in a jackpot and now find themselves in the criminal justice system. To the extent possible, documenting brain injury in the court process may not only shape court outcomes and sentencing, but also setting conditions that are more responsive to client contexts. So a defense lawyer told us, I will get from the client a copy of the psychiatrist or doctor's reports, indicating how they acquired the brain injury as well as what that means in terms of their functioning. I often think that's important for the judge to have it, to have a better understanding of the person's capacity, to at least mitigate how they see the person's criminalness in terms of the offense. Usually it will result in a lesser sentence or some sort of different sentence that where the judge is really actually trying to help the person, trying to get them to be on the right path and get the right help. Using plain language and trying to avoid jargon or translate jargon is so important in these criminal legal contexts, fast-paced interactions with legal actors, such as in the courts. If you're a cop or you're a justice of the peace, you're using terminology and somebody will have no idea what you're talking about. And that's something you got to be careful about when you're presiding in court. I would try to explain in plain language when I realized that a lot of jargon was going back and forth, such as primary ground, secondary ground, tertiary ground. So you got to, explain to them, okay, here's the deal. The primary ground means you're going to show up for court. Slowing down the communication process, assessing understanding, and then seeking support when necessary. For example, once you've realized and established the fact that the cognitive factor in this individual may not be there, then you better back it down to be able to at least establish in your mind that they are understanding. You as the presiding judicial officer could go, whoa, hold on a minute. There needs to be an assessment done here. How might we set conditions in ways that are more responsive to brain injury so that people can better understand them and be better able to comply with them in the community? Well, a justice of the peace told us it really requires digging into the details of some of these conditions. For example, if an order of the court is to reside at a certain place, stay away from this place, you got to really sort of think about it. Because, again, boilerplate. Crown will say 100 meters away from 50 Smith Avenue. Well, hold on a second. The individual has got a brain injury. Most people don't know what 100 meters is. Focus in on the details so that you're not creating a potential for another breach and I guess a potential for failure. Some of you noted being realistic with your expectations for people and like finding out what works best for them. Now, I know you need to set conditions, the system needs to set conditions, but multiple participants noted that it would be helpful if they could be involved in these conversations early on in the process so that it can flag what may or may not be feasible in their context. You can tell anybody to jump 10 feet. It doesn't mean everybody can jump 10 feet, right? Court navigation and debrief supports were also something that our participants flagged. A critical moment is that immediate post-release period. We know in the literature But we also heard that from participants with brain injury around like what exactly just happened in there and what are my conditions, what do they mean, and what are my next steps? So somewhere in all those rooms where there's like probation, there's duty counsel, there's Crown's office, all these offices, maybe one of them can be just to explain how to start rolling with this. If the client has any questions, somewhere that they can go with their papers and say, I was just too nervous in there. I didn't catch it. I heard something about a police station and an address and probation officer. Could you help? And they help you work through those papers for a few minutes, exactly what the next steps are. You also noted, the audience noted setting clear expectations and setting clear plans, and that was noted by a number of clients. Got it, Connie. Be clear with what's expected. Be clear with what's expected. I found that some probation officers were very, very short and blunt. You get in there and they just talk down to you. They're very short and you don't even feel comfortable to ask. But to not set up for failure, just like I said, explain everything that's expected of the client, because sometimes we don't even know our own questions. People have to have a plan, like for me, that don't do well with change and struggle if there's like a sudden change or expectation to the day. It won't always work, and they're not able to adapt and handle that. So expecting someone who is disabled to be able to just handle something that's just so sudden is difficult. Appointment overload was mentioned by a number of participants. So to the extent possible, staggering the schedule of appointments to avoid that overload and overwhelming clients can be helpful. You've got so many appointments, so that's just part of it. But you don't have to send the person to 4 different groups. Maybe send them to one. When they complete that one, they're with you for a couple of years usually. So you don't have to send them to all of them at once. Maybe put it over time. So much in the literature focuses on breaches and recidivism, right? Returning to custody as this individual phenomenon. But as we have seen and we've explored in this qualitative work, it's best to envision the community supervision process as a social process, an interactive process. Sure, there are folks under conditions, but there are people setting those conditions, enforcing those conditions, and supporting them in the community. And to see someone succeed in supervision is often a product of a community collective effort. A couple of times I missed it, and she would call me, oh my God, did you realize that you had an appointment with me earlier this morning? But then after missing a few of them, she got to know me and knew that I didn't do it intentionally. And I wasn't lying to her, and it was, out of a natural order of my condition. Thank God, but she knew. I did tell her about my brain injury and stuff like that. And finally, part of being more responsive to brain injury is having greater awareness of brain injury and how those challenges manifest in everyday life, and to approach setting, monitoring, and enforcing conditions with that health-informed lens. Let's say that a client is MIA, missing in action. They didn't meet their appointment. That does not necessarily mean that they're purposely missing their appointments. It's not purposely because they're lazy and don't want to go and want to be jerks and get breaches. It's overall, it's a brain injury. It's a condition. Look at other factors, as to why that happened. And if they meet all that criteria, that falls under a brain injury, as opposed to being careless and lazy. So those are some of the challenges and strategies that we heard from our participants, and we're looking to continue to add some perspectives, especially of justices and probation parole officers to the study. But I just want to leave you with these 3 points quickly in sum, the implications flowing from this work. We saw that the challenges of brain injury in those 4 domains, cognition, communication, behavioral and emotional control, overlap significantly with the challenges of conditions, understanding them and complying with them in the community. We also saw that, it's too simplistic to reduce compliance to an individual process, but rather that a variety of players in that social process of supervision can affect people's trajectories through the system, how they understand conditions, what conditions are set, and then how they may or may not be supported in complying with them in the community. And 3, all of these challenges that we've noted here represent opportunities for accommodation and intervention. So we could be doing a better job of supporting brain injury awareness and accommodation through training and education. We could be doing a better job of identifying and accommodating brain injury early on in the process. We could be doing a better job of setting and enforcing conditions in ways that are brain injury responsive. And we could be doing a better job of providing support in the community, like providing navigation support and other compliance-related supports. So thank you for listening, and I can now open it up to questions. And my colleagues too. Actually, Connie, you're a colleague as well. But my colleagues Madison Ford and Flora Matheson, you're welcome to jump and join in as well. And I think Jennifer's collating the questions in the Q&A.
Hello. Yes, that's right. So I've asked participants if they could please put their questions in the Q&A box. We do have one question. As a service provider and ABI educator, what is the best way to approach the judicial system to provide education and help them to navigate ABI clients? Is there a typical liaison for this?
Is there a typical liaison for this? I think it depends on the context. Right now we are, and I'm anticipating a presentation of my colleagues, Dr. Flora Matheson and Lucy Gudgeon from Elizabeth Fry Society, who are piloting a program at the Toronto Regional Bail Centre. And so I think that program, like in the bail process, has a specific brain injury bail navigator. That's not going to be in place. That's a specialized program, but before there was that program, say in the bail process, duty counsel or criminal defense counsel would be a good point of contact to raise the potential issues that clients are facing and trying to communicate that to their counsel so that they can advocate on their behalf and include them in that process to the degree that they can. There may be other avenues into the process. I know that there are mental health support workers and programs at the courts as well. And what we've been hearing is that they often are encountering clients who may or may not have co-occurring mental health concerns, but they have brain injury concerns and they don't necessarily have a response to that. They are looking for supports, they're looking for connections in the community. So connecting with and getting to know those mental health coordinators and court workers might be a good way in, a good avenue in. There's Toronto Bail Program. Working directly with, reaching out to their supervision officers, perhaps attending and accompanying them on appointments. Supervision appointments, introducing yourself to those various players in the process that have some control over the direction of that process. And finally, there are kind of one other set of players in the process would be at community residential facilities and halfway houses. Flora, I don't know if you had any ideas.
Yeah, I'm just trying to interpret the question. And so the way that we're trying, maybe if I answer it in the way that we're trying to provide education. Sure. So we've just had a series of meetings with all of the key interest holders at the Toronto Regional Bail Centre, all of the community groups there, the Duty Council, Crowns, and we're working to speak with the Justice of Peace there to develop a set of educational modules for them. So I'm not sure if you're speaking from that perspective or if you're speaking from your work on the ground. But I think any opportunity you get to provide education, even when you're talking with duty counsel and mentioning, the prevalence of brain injury, which is upwards of 88% in the population and upwards of 95% for women. Just any time you have an opportunity to have a discussion and say that this is an issue on top of the other complex needs in the population is an opportunity for education. So I'm not quite sure exactly the interpretation of the question I'm trying to interpret it, or are you, but we are doing education. The Breaking the Cycle Solutions Network, individually, all of the members are doing education across the different professional groups, and we're also doing education. So I'm hoping between Arthur and I, we've answered your question.
Yeah, 2 ways in, advocating for specific individual clients. So that's one way in, right? But then there's that opportunities for the more general education and advocacy. And what we've been hearing, I mean, of course, based on the needs assessment that we're doing up at the Bail Center, is as much as possible. I mean, educate yourself on the work that these criminal legal professionals are doing so you can provide some concrete scenarios and strategies for them to flag, to support people through the process and include them in the process. But almost all of I would say, of the interest holders are interested in this type of education, especially some concrete strategies you can provide them to support their work.
And if our research or other research, if we can help you with research and numbers and things like that, then we're happy to do that. So let us know.
Awesome. Thank you so much, Arthur and Flora. Another question from a participant is, are there screening forms or pathways for a brain injury diagnosis for people currently incarcerated? How can people get diagnosed while incarcerated?
Laura probably knows best about, there's a screening. Okay, so there's screening and then there's diagnosis. The two are distinct. So screening may suggest a potential brain injury, but it's not the same as diagnosis. The process of diagnosis, I mean, even Connie could probably speak to that, what the pathways in the community are like for achieving a brain injury diagnosis. But there is in Solgen screening ongoing, right, Flora?
Okay, so it's very difficult to get a diagnosis at this point in time. There aren't a lot of brain injury services in Ontario, and the ones that are available, you have to have so the brain injury services that are available. So in order to get access to brain injury services in Ontario, you have to have a diagnosis, but it's very challenging to get a diagnosis because there aren't a lot of, many people don't have family doctors. And so it's very challenging to get in to get that diagnosis. Many people have had an injury, a history of brain injury, but don't have the diagnosis at the time. And then to establish the diagnosis after the fact is very challenging. So that is a problem for this particular population. There is a HELPS screener that is used by the acquired brain injury navigators. It's also the screener that is being used in the pilot project that we're going to talk about tomorrow in our presentation, the presentation that Lucy and I are doing. But it is a screener, it's not a diagnosis. So as I say, it's challenging right now. It's challenging to get a diagnosis and to get treatment as well, and to get into OHIP related services. I don't know, Connie, if you want to add to that.
Yeah, I was just going to say, at this point, the help screener is the best way to alert you that, I maybe need to look at this file a little bit differently. And by implementing some cognitive friendly strategies, then you can support the person better. And that would be my recommendation while they look to options. And certainly they can connect with the Ontario System Navigators for brain injury to look at options so that they could pursue medical supports to get a diagnosis.
Awesome. Thank you so much. We will have time for just maybe a couple more questions. So another question from a participant. We often have clients who present as having an ABI, or based on information they disclose, it's very apparent that they do. However, it's often difficult without an official diagnosis to get them the support that they require. What would you suggest in terms of having them assessed or getting ABI supports in place? Many of these clients do not have adequate housing, mental health and addictions issues, and do not have medical records.
Yeah, that's a huge challenge, right?
Yeah, I think Connie just answered that in the best way that it can be answered. We're also having that challenge with the new pilot project. Because one of the hurdles too is that if there's in some of the services, if there is existing mental health challenge, then that has to be addressed first before people can get brain injury services, even if they have a diagnosis. So I think there are hurdles in the system. And one of the unfortunate things, and Dr. Bosseri spoke about it today, that the services are not integrated. And so there are silos, and it creates some challenges for very complex patients and clients. Yeah, I'm not sure what else to say. Connie, do you have anything else you want to add to that?
Yeah, I was just going to say, I agree. And I think by, reaching out to maybe one of the system navigators for ABI, they can provide, if there's an indication of a brain injury, they can provide some resources in the community that will, that are at no cost, that can provide supports to the person, whether it be through Ontario Brain Injury Association or, there's different educational websites that are available that people can access information themselves, and that can support them.
Thanks, Connie.
Thank you. We'll take one more question before we wrap up today. A large part of the demographics I support in community are living with brain injury and often miss court dates or forget to attend required programming in a restorative justice court. When these issues arise, I often hear integrity of the court as justification to place folks from this restorative justice system into a case management court or even force a resolution. How can I better advocate for the courts to observe patients when working with our community members with brain injury?
Better advocate. So we came across some instances, I'll just speak to the data. We came across a number of instances of providers supporting clients with brain injury in the system, like for example, a number of bail supervision officers, and really their success in advocating on behalf of clients came down to the specific crowns or courts they were dealing with and the personalities and players in those courts and the relationships with them. And so they were sometimes able to navigate some of those breaches or get exemptions around some of the breaches when they did occur, but sometimes not too. I don't know. I'm struggling with how to better advocate on behalf of those clients other than to make them aware of brain injury and the set of challenges that are associated with it, and then the plan of supports and plan of action to help support them to attend these meetings.
I'm going to have to wind us up, unfortunately. But I agree that I think education and knowing some resources for support is the best way. I just really want to thank our presenters today. It was an excellent presentation. Thank you very much. And I want to really encourage all the participants to fill in the survey. If you go to the agenda, and you will see beside the session that you joined, there is a survey button. If you can please fill that out. And then I'd also remind you that during the next hour, it's going to be a break for lunch, and you can also go and look at the poster and exhibitor halls and get some personal resources for your swag bag. Thank you very much for your time and your active participation in the session.
Yeah,
Have a great
thanks
day.
everyone.
Thank you.
Thanks.